Hey everybody, it's Friday night. Welcome to my channel. I'm Anjanette Levy. If you're just joining me, thanks so much for doing so. If you've been here before, welcome back. And thank you to all of our new members. We just launched the memberships last night, and so far we're off to a great start. So if you'd like to become a member, there should be a link to do so on the page. If you're just joining also, please subscribe if you haven't already. Give us a thumbs up, the like, and hit that bell. And if you're watching on replay, thank you so much for watching on replay. I always love it when everybody's watching on replay and I go back and see that people have. Let me know where you're watching from. Put your state, your city, whatever you want to do, and we'll give you a shout out. So thank you so much. Thanks to all the mods tonight. The docket is here. The Melmac is here. Webby is here, as is Monty. I believe Monty's in the house, and Mo. Mo is now joining us as a mod too. So thank you so much, everybody. Let's go through some of the people in the chat already. We have Jennifer Smith. Hi. Kim Hastings from Maryland. Hello, Kim. We have John Gahan from he says, hey, hi, Anjanette, big fan. Thank you. I don't know where you're from, John. Sorry. Maui girl is in the house. Aloha from Maui, I'm assuming. She says, aloha Friday. Hello, Friday. Taya Toys is in the house. And I'll show you guys a little bit later at the end of the stream what I got from Taya Toys. It's super cool. Super cool. So it's really neat. So we'll talk about that later. Debbie Cotman is in the house from Canada. Thank you so much for watching. And G of Twins is here from Arizona. So it's we got a full house so far tonight. We're at 71 viewers so far. Invite your friends, tell them to come on in. We're going to be talking about the Bryan Kohberger case. There's a lot to talk about, right? Lots to talk about in this case. Judge Hippler, of course, as you know, denied the defense request to continue the trial. The defense said, you know what, Judge, we need more time. And he said, you know what, you've had enough time. You should have brought this up way earlier than you did. So we're going to trial in August as anticipated. However, opening statements will start a week later than first anticipated. We'll get into a little bit more about that later. He also denied the defense's request to present information, evidence to the jury about alternate perpetrators. Those are other suspects. I call it some other dude did it evidence. You know, in a lot of cases, you'll see that people say, hey, I didn't do this. I didn't commit this crime. We just saw it in the Karen Reed trial. She wanted to point the finger at other suspects, and the judge really didn't allow that. But you have to make an offer of proof in a lot of states. You have to show the judge, here's my evidence. Here's why I think I should be allowed to do this. It has to kind of reach a certain bar for the judges to allow that. And in this case, Judge Hippler said, you haven't done that. And we're going to go through why he says they didn't do that. We kind of went through some of this last night, but we did it very, very quickly. And tonight we're going to do a little bit deeper of a dive on this topic. So let's get into that. And then we'll look more into his decision to deny the continuance, the request for the continuance. And there's some goodies hidden in that as well. I think you're going to really like that, because we have some information in there that I think is really interesting based on things we've talked about before. And it's interesting about the leak or leakers, the leaker or leakers to Dateline, some things that are written in there. And there's also something new on the docket that hasn't yet posted yet, but it's on there, and we should be getting that hopefully on Monday to learn a little bit more about that. So let me get to it. We'll get straight to it. Again, guys, please give me a like, a subscribe, and that thumbs up, hit the bell. That really helps the video, and it will help spread it through YouTube. And we really love that. Let's see. Oh, also, everybody, I want to thank you. I have passed overnight. I woke up this morning and we passed 10,000 subscribers. That's huge. So we couldn't do that. I couldn't do that without you guys. So thank you so much. I'm getting word that there's something going on the screen. And again, welcome to Von Cruel, our newest member. Okay, so here is the redacted order. Now, there's going to be a lot of black on this piece of paper. It's the defendant's offer of proof, re alternate perpetrators. So this is the some other dude did it evidence, and this is the redacted order on the defendant's offer of proof. And so basically in the state of Idaho, there's a case called the Meister case, and they have to be able to show the defense has to show the judge, hey, I've got some evidence and I should be able to point the finger at these people. And this is why I should be able to do that. This is why I should be able to, I've got this offer of proof. And they did this under seal. They're not going to, the judge is not going to allow them. And it would be pretty irresponsible of the defense to just throw a document out there without sealing it, naming people, naming names, saying, we think this is why we should be able to point the finger at these people. So let's start up at the very beginning, the introduction of Judge Hippler. I call him Judge Dry Sass, of his his order here, and why he says the defense should not be able to present this information. So he says in the very beginning, the state, and the state opposed this, of course. The state doesn't want them presenting this evidence because they say there are no other suspects. They've said that in other court filings. The state previously moved in limine to preclude the defendant from offering or arguing alternative perpetrator evidence without first satisfying the applicable evidentiary standards. In accordance with the court's subsequent order on the motion, defendant filed his offers of proof and evidence in support, identifying four individuals. He had four people. Remember, Ann Taylor said she had all of those tips. She had what, 9,000 or no, it was probably more than that. It's actually way more than that. Thousands, tens of thousands, I think, of tips that were submitted in this case, identifying four individuals as potential alternate perpetrators. Ann Taylor said she had not been able to go through all of those tips, but she said they found a lead recently, and she felt that that was a pretty good lead that they had discovered. And I think I know which one she's talking about. So the state objected to this, and they cited the Meister case. The court concluded at this time that the defendant's alternate perpetrator proffer is inadmissible under Meister, as it is irrelevant and or excluded by Idaho Rule 403. However, this does not foreclose defendant from cross-examining law enforcement regarding the reasonableness of its investigation and its follow-up on plausible leads. And he goes through and he talks about the standard. The legal standard states that trial courts have broad discretion in the admission of evidence at trial. And he cites another case. A trial court acts within the bounds of its discretion when it correctly perceived the issue as one of discretion, or acted within the outer boundaries of its discretion, acted consistently with the legal standards applicable to the specific choices available to it, and reached its decision by the exercise of reason. So he goes through and he talks about the admissibility under Meister of alternative perpetrator evidence. And he said, prior to Meister, a defendant wishing to present such evidence at trial had to first present proof of connection with the crime, such as a train of facts or circumstances as tend to clearly point out someone besides the accused as the guilty party. Remote acts, disconnected and outside of the crime itself, cannot be separately proved for such a purpose. So he goes through what Meister means. And so we get to page 2. We're on page 2. And he said here, the evidence defendant has proffered purporting to establish the four individuals as alternate perpetrators abjectly fails to meet the Meister standard. Namely, the evidence is entirely irrelevant. Nothing, and Judge Hippler says nothing, links these individuals to the homicides or otherwise gives rise to a reasonable inference that they committed the crimes. Indeed, it would take nothing short of rank speculation by the jury to make such a finding. Three of the individuals, three of them, and there's a footnote down here, and it's of course all blacked out. It's all redacted C. So I always love reading the footnotes. You get a lot of meat on the bone in the footnotes. This one, unfortunately, is all blacked out. Three of the individuals were each socially connected to one or more of the victims, interacted with one or more of the victims at social events in the hours prior to the homicide. This gets me thinking about the Sigma Chi house, potentially. Lived within walking distance of the crime scene, again, Sigma Chi house, and were familiar with the layout of the victim's home from prior social events. This all has me thinking, just because I've been there, of the Sigma Chi house. Now, it could have been anybody else living in that neighborhood. They call it Greek Row, and if you go to King Road and you go to that area, you've got the big apartment building right next door. You have a lot of other student housing. I think Ann Taylor was going for frat boys with this alternate perpetrator evidence. And we're familiar with the layout of the victim's home from prior social events. While perhaps this evidence could suggest an opportunity to commit the crime, which no doubt is an opportunity shared by dozens of others, in the victim's social circles, there is no compelling evidence that any of them had a motive to kill the victims, much less physically harm them or a means to do so. Further, there is no evidence connecting them to the crime scene. They have each cooperated with law enforcement, providing DNA samples, fingerprints, and allowing searches as requested. Notably, lab testing has excluded their DNA from samples taken from the crime scene and victims. So right there, I am suspecting, here's my rank speculation, but I think I'm probably right, given the fact that when I was out there, there was a lot of talk, a lot of people pointing fingers. Oh, it could be this person, it could be that person. We were hearing a lot of rumors. We were hearing things about how Ethan and Xana had been at the Sigma Chi house, at the party. I think that one of the surviving roommates had also been at the Sigma Chi house party. I'm thinking they're going for frat boys there, but I went to the Sigma Chi house a couple of times, knocking on the door. You can imagine how that went. They were completely polite and fine, but they didn't want to talk to us. And they were told not to talk to us. Their friend had been murdered, so they weren't going to talk. But they're saying here, Judge Hippler is saying they cooperated with law enforcement. Further, there's no evidence connecting them to the crime scene. They've each cooperated, as I mentioned. They provided DNA samples, fingerprints, and they allowed searches as requested. Notably, lab testing has excluded their DNA from samples taken from the crime scene and victims. Very interesting, because we have heard about the DNA under Maddie's fingernails. Remember, we've heard about the unidentified male DNA at the house as well. The stuff on the spot on the banister, and then the stuff on the gloves. So far, guys, what do you think about this? Do you think I'm right about this whole thing about it could be the Sigma Chi house? It could be the fraternity brothers that they were trying to suggest as alternate suspects, because that's my feeling on this. And I'm going to hop back into the chat here and see what everybody is saying. Geo of Twins says, in my opinion, I bet BK is giving ideas to AT because they are really reaching. Messica says, grasping at straws. Amelia Outlaw says, maybe the defense threw out a few placeholder names just to secure the right to cross-examine, but they can cross-examine anyway. And they, I'm sure, could cross-examine these witnesses if they're called at trial. They can cross-examine law enforcement. They could potentially call these witnesses. They can cross-examine law enforcement. Okay, so did you talk to this person? Did you talk to that person? There are a number of ways you can ask about people you're talking about without saying in your opening statement, I think this guy did the crime. Peppermint PJ says, so Ann Taylor wants to set up some innocent student. I don't know. This is my theory on where she was going with this, based on how I'm reading it, the layout of the neighborhood, living within walking distance, one or more of the victims having interaction with these people in the hours before the homicides, that type of thing. Johnny Knoxville says only Bryan Kohberger's DNA is on the sheath. And you've got a point there. We still need to know how they are going to counter that. Are they going to say it was transfer DNA, or are they going to say that the sheath was somehow transferred there by somebody else? Was his sheath stolen? Because we know he owned, or at least purchased, a K-bar knife and sheath. All right. So let's move on to the other part of this. If you're just joining, thanks so much for joining, everybody. And if you're watching on replay, thanks so much for watching on replay. Remember to give me a thumbs up, like, and subscribe. And if you want to join as a member, that would be great too. We've got a little issue with the chat tonight. It's a little slower than I would prefer it to be. So we'll fix that for next time. I was just trying to slow it down to keep up with it a little more easily, but sometimes settings don't always work the way you want them to. So apologize for that. If the chat is a little too slow, just bear with me there. All right, so let's get back to this. So the fourth individual, and again, we've got more redactions on this page, more black. The fourth individual did not know the victim, but had a passing connection to one of them while noticing her shopping at a store approximately 5 weeks prior to the homicides. He followed her briefly out the exit of the store while considering approaching her to talk. He turned away before ever speaking to her. The event was captured on a surveillance camera. This individual subsequently cooperated with law enforcement, providing his phone number and a DNA sample. As with the other alleged alternative perpetrators, lab reports excluded his DNA from the samples taken from the crime scene and victims, and there is no evidence connecting him to the crime scene. This, I'm wondering, do you guys remember when Ann Taylor, I believe it was at the April hearing, said something to the effect of, recently we've come across a tip that suggests an alternate perpetrator, and we need to investigate that further. I don't know if this is what she is referring to. It could very well be. So that could be interesting if this is who she was talking about. But I don't know what further investigation she would need. I mean, you could carry out a homicide and your DNA is not left at the crime scene. That's entirely possible, that you can carry out a homicide and you don't leave your DNA there. In this case, they're arguing that the perpetrator left his DNA, more than likely accidentally, in a frenzy at the crime scene, just a little teeny tiny spot of it. So we'll go on a little further. We do have one footnote that is, we can read. So let's look at that really quickly. The fact that these individuals live within walking distance to the crime scene is not probative evidence, given that the perpetrator drove a vehicle to the crime scene. Further, none of these individuals drove a vehicle matching the description of the suspected killers. So the judge is basically saying the killer drove there. So that's really interesting. And he's saying, obviously, the judge is concluding that the perpetrator drove a white vehicle. This is what he believes, given this footnote. And he's saying none of the four people drove a vehicle matching the description of the suspected killer. Collectively, defendants' proffer with regard to these four individuals fails to give rise to even an inference that they committed the crimes, or otherwise make it more or less likely the defendant was the perpetrator. Therefore, it's irrelevant under IRE 401. Defendant has provided no probative, admissible, significant evidence of motive, ill feelings, means, presence at the scene, or any other connection to the crime that could possibly move the ball to the extent that it supports an alternate perpetrator theory. So let's go down to our footnote at number 5. As the state notes, none of the 4 individuals drives a car that could be mistaken for a Hyundai Elantra. That was in the state's objection, which was also sealed. At best, defendants' offer of proof can give rise to only wild speculation that it is possible any of these 4 individuals could have committed the crimes, which is inadequate under Meister. Again, mere inferences that another person could have committed the crime will most likely not be relevant. In other words, it's not sufficient for a defendant to merely offer up unsupported speculation that another person may have committed the crime, which is all the defendant has done here. Even if there was a shed of probative value in the proffered evidence beyond wild speculation, it's excluded. And he cites case law, and then he cites the Timothy McVeigh case. Likewise here, presentation of the proffered alternate perpetrator evidence would pose a great threat of confusing the issues because it would force the state to defend against a nebulous allegation that perhaps these individuals were involved. This foray would lead the jury astray, turning its focus away from whether defendant, the only person whose actions are on trial, committed the charged crimes. It also presents a threat of unfair prejudice, as it would invite the jury to blame unrepresented persons for a heinous crime when there's not a scintilla of competent evidence connecting them to the crime. Finally, it would do nothing more than waste the precious time of the jury and the court in what is already a scheduled 3-month trial. I always love it when judges use the word scintilla. There was another trial I covered where it was either a judge or somebody used the word scintilla. Scintilla is a great word. Nonetheless, the court's ruling does not preclude defendant from confronting and cross-examining the state's law enforcement witnesses regarding the thoroughness of the investigation, particularly in following up and ruling out leads generally. I'm going to be really interested to see when the detectives get on the stand, specifically Brett Payne and this Gilbertson, who was with Idaho State Police or is with Idaho State Police. Okay, guys, how many of these tips did you go through? Did you run down all of the leads? I remember in the Pike County case in Ohio, that was an octuple homicide case. I think they said they had like 9,500 tips. And Ryan Scheiderer, the lead investigator in that case, said they ran down every one of those leads. Every one of them. I am going to be very interested to see whether or not the cops in this case looked into all of these leads or went through them to try to rule them out. What do you think? Let's look at your comments in the chat real quick and see what everybody's saying about this. Oh, beautiful messy ball. Hello. Tara, personally, I think the crime most definitively could have happened by foot. That's interesting. So Tara thinks that this could have happened by foot. And Tara, I'm so sorry. Did you just join as a member? If you did, thank you so much. And beautiful messy ball. Beautiful messy ball says, I'm pretty sure Alessi used it as an oral motion to dismiss. Okay, so you're talking about something else that I missed. Thanks, guys. Von Krull has said something. Von Krull says, not familiar with the precedent, but the decision jibes with common sense. How would a flaky accusation with no meat on its bones do anything other than muddy the waters? Sirius Black says, excellent comment to Von Krull. So yeah, there's a lot here, guys. Emma Clayton likes the neon A. I'm so glad you do. Carolina Hurtado is in the house. And it appears you're a member now, Carolina. Thank you so much for joining. She says, to be honest, the two roommates shut down emotionally and went into fright and flight mode, both locked themselves in one room and stayed there until they felt safe enough to come out. They called friends. I mean, that very well may be true, and we'll hear from them at trial. We definitely will. So we are going to hear from the roommates are going to testify at trial, and Judge Hippler's, he anticipates that. The state has said they anticipate calling them. So we know we're going to hear from them. It'll be interesting to see what they say, because I'm sure they will be asked about that. And we will hear them say in their own words why they did what they did that morning. They'll be cross-examined. We may not be able to see them. The judge said if they don't want to be shown on camera, he's going to allow them as crime victims not to be shown on camera, but we will be able to hear their voices. Megan Mangold has become a member. Thank you so much, Megan. Welcome. Welcome to the Anjanette Levy channel as a member. Thank you so much. Flash your emoji. I'm trying to monitor when on my phone when people join. So thanks so much. Let me pull that up so I can make sure I'm seeing when everybody joins. All right, so let's get back to the paperwork. Nonetheless, the court's ruling does not preclude defendant from confronting and cross-examining, I just mentioned this, the state's law enforcement witnesses regarding the thoroughness of the investigation, particularly in following up and ruling out leads generally. That's just what I mentioned. Indeed, the Idaho Court of Appeals recently found in an unpublished opinion that questioning a detective about failing to follow up on other plausible leads was relevant to alternative perpetrator analysis. We agree with Emerson that a relevant line of inquiry would be to question the scope and breadth of the investigation and to explore on cross-examination whether plausible investigative leads about third parties were ignored or overlooked. And so then he says the court will apply these parameters at trial regarding defendant's cross-examination of law enforcement. He may inquire as to the reasonableness of the investigation, including investigating and ruling out other leads. He is not, however, permitted to question law enforcement about the investigation of any specific individual as a potential alternate perpetrator without first raising the matter with the court outside of the jury's presence. So he says you can grill the cops. You can grill the cops really hardcore on this. So that's what he's saying about that. Oh, we have another new member. Beautiful you. Welcome. Thank you so much for joining. Appreciate it so much. Everybody, welcome. If you're just joining, thanks so much for coming in. Please give us a thumbs up on the way in, like and subscribe, hit the bell. Giving us that thumbs up really helps the video and helps the channel. And beautiful you, thank you for joining. Flash your emojis, do whatever you want. Flash your badges, all of it. Johnny Knoxville, thanks for the super chat. Appreciate it. If you recall, Ann Taylor failed to establish an alibi. She's failing to prove an alternate suspect, and autism claim came up very late in the game. And if you recall, the autism claim, they're not going to be able to tell the jury about that. That's and not until possibly mitigation. So, their defenses. I think the defense is just going to have to be our guy didn't do it, and we don't know who did it because they rushed to judgment. I think that's going to have to be the defense in this case. That will be the defense in this case. How do you feel about that? I think that's where the defense is going to have to be going. They see this sheath and they get a DNA sample, and there was a rush to judgment and they had to make an arrest. There was too much riding on this, just too much. They had to make an arrest before school started again. There was pressure from the University of Idaho, and they had to get it done. So that's how I think it's going to go. So let's get now to the stuff about the continuance. We'll do a kind of a closer look at that. And let's look at what they're saying about the continuance, or what the judge said about the defense's request for a continuance. And because he revealed some new information in here. Oh, Taya Toys. Hi. Thank you so much. I think you became a member too. So thank you. I see the green. Thank you for joining. Taya Toys says some people are treating BK like the new Karen Reed. Well, we shall see. We shall see. So here we go, guys, on the continuance. We went through some of this last night, and we're going to hit on the things in here that I think are really important, including, and I'm going to put this up really. Angie says, I think this case is bigger than Karen Reed. I would agree with you, Angie. I think that too. A lot of people are acting like they're on the same level, and I don't think they are at all. I think this is much bigger, and I'm not saying this is not an insult or throwing shade at John O'Keefe or his family or anything. I'm just saying with worldwide interest and things of that nature. And we have 4 young people. The crime alleged by the Commonwealth in the Karen Reed case was a domestic violence homicide, essentially a vehicular homicide. So I would agree with you. This is 4 young people. This was a complete whodunit. All right. So back to the paperwork. And thanks for everybody who's joined. I so appreciate your support. Oral argument on the motion was held on June 18th, 2025, after which the court took the matter under advisement. The court finds a continuance is not warranted as defendant has not made a showing that there is good cause to continue the trial or that his substantial rights will be prejudiced by proceeding to trial as scheduled. So now we have our little footnote here. Defendant filed some of his supporting materials ex parte, while the court is not convinced that much of his filing is necessary or appropriate to be treated as ex parte. Little shade there from Hippler from Dry Sass. The court will nevertheless, in an abundance of caution, issue a redacted and unredacted version of this order, with the state only receiving the redacted version, given that the court is denying the defendant's motion. What I really want to get to, they're saying they've had all this late discovery. They haven't gotten things until late. They've gotten things thrown at them where it just said hundreds of photographs, hundreds of, crime scene photos, this, that, and the other. And they just basically sound like it's just been a hot mess. And he's like, well, why haven't I heard about this sooner? And the question I have really, and it came up in the Pike County case, I keep bringing that up because that's a case where there was like tons of evidence, tons and tons and tons of evidence. And we heard from the very beginning about the prosecutor in that case copying over terabytes and terabytes and terabytes of evidence, right? And so that's the only thing I have to compare it to. And so there were terabytes and terabytes, probably more than 10, 12, 15 terabytes of evidence. In that case, a lot of it was video evidence. And you had 8 victims in that case. And so they brought up the issue, the defense did actually, because we had 4 defendants in that case, of hiring what they called a discovery coordinator. Well, the judge in that case, it's Pike County, Ohio. He's like, a discovery, what? And, even though they were getting money from the state, Pike County was like one of the poorest counties in the state. They were getting money from the state legislature to pay for these trials because the county was so poor. But Judge Deering's like a discovery coordinator. What? Can't you just like figure this out? So they never hired the discovery coordinator, but that's somebody who can like go through all this stuff and organize it for you. You're talking 68 terabytes of evidence. Please tell me why you didn't bring up hiring a discovery coordinator back in 2023. If you know you're getting a hard drive or 3 or 5 with all of this data, why didn't you bring it up? Unless maybe, the cynic in me thinks, did you keep this in your back pocket in case you knew you were going to need it at a later date? Like, oh, I just can't get through all of this discovery. It's just too much. It's just too much. We need a delay. And I don't know why she didn't try to continue the trial sooner. I really don't. I feel like they should have tried to file for a continuance much earlier. Especially after transferring venue, winning the change of venue, and then saying, Your Honor, we need more time. We need more time. I mean, she had told Judge a long time ago, maybe 2026, but I don't recall if she ever brought it up to Hippler. If she did, let me know. Oh, Monty, thank you so much for becoming a member. How sweet of you. Thank you. Thank you so much. I see we've got some new people entering the chat as well. Thank you. Very sweet of you to join. So no discovery coordinator was hired. Please remember, as you're entering, to hit the like and the subscribe, guys. It's a big help. I really appreciate that. We're also, after we get through the goodies in this, I'm going to show you this new thing that I told you about that is on here that's piqued my interest. Super interesting. Super, super, super interesting. We got to keep an eye on it for Monday. I think on Monday we might get something posted about it. So back to the document. He's basically saying you've waited too long. The defendant has not demonstrated a continuance is warranted for review. He said all of her complaints are kind of empty complaints. Down in this footnote, defendant's continual reference to the number of terabytes of discovery produced in this case is not helpful without providing a meaningful explanation of what that data primarily consists of and its particular relevance and importance. Indeed, as was discussed at the April 9th, 2025 hearing in this case, it appears that most of those terabytes consist of extensive video surveillance from local businesses and residences that show nothing of significance. In fact, the state indicated at that hearing that much of that discovery is completely irrelevant and stipulated that it is unaware of any Brady material in the video surveillance footage other than specifically identified in motion practice. Given that the state has identified all of its trial exhibits, the defense cannot be unaware of all the incriminating evidence in the discovery. Finally, it should be noted that it was defendant who early on demanded that the state provide all investigative materials, no matter how irrelevant or unhelpful. So he's saying you asked for all of this. And then he talked about how the court, however, rejected this whole argument about all this. There was just too much stuff. We got too much stuff dumped on us. It wasn't indexed. There was not a hot sheet, all of these things. They rejected this same argument 2 months ago when defendants sought to strike the death penalty and impose discovery obligations upon the state. In its order, the court observed the utter lack of any proof supporting defendants' accusations of discovery violations by the state. More importantly, the court found defendants' complaints of being unable to meaningfully review discovery entirely unconvincing, pointing out that counsel struggled to articulate in any meaningful way what evidence, let alone relevant evidence, counsel has been unable to review over the past 2+ years, and why efforts to facilitate discovery review were not made long ago through this court and or the resource judge. He had told her back in April, maybe you need to go get some, did you ask the Judge Monson, I think was his name, for more paralegals? And she was like, well, no, I could do that, but I like to look at everything myself. And he said, well, basically in a huge case, it's not uncommon to have paralegals going through everything. And then they give you something that they know is important. And they say, hey, here it is. So he's saying, why didn't you do that? And actually, somebody brought up the Karen Reed case. In the Karen Reed case, that happened. In the Karen Reed case, I saw a picture online. She apparently had a bunch of interns, law school interns, I believe, or law students working on her case. She was working on her case. So this can be done. This can be done. What do you guys think of that? It sounds like he's just saying you already chose this argument. You tried to get the death penalty stricken. It didn't work. Yeah, Tara says 5 law students. Right. I saw the photo online. She had beautiful messy ball says she had Harvard interns, second trial only. But my point being, I am sure there are law school students in Idaho or law school students anywhere for that matter who would, or law school graduates who might be willing to work on this case pro bono for the experience, I would think. So, guys, let's move on now to the pretrial publicity part of this, because I think that's where it gets really interesting and we learn some new information. So let's get into this right now. Yeah, I had Nightbot downloaded. Peppermint PJ says Nightbot is a meanie. I downloaded this Nightbot earlier. I'm beginning to wonder, was that a mistake? I don't know. I did something, but then I just deleted it from the moderator thing because apparently people were being put in timeout, and I'm sorry about that. So again, if you were being put in timeout, I apologize for that. So let's get on now to the stuff about the pretrial publicity. And then we'll get to the new mystery documents. Oh, this was a good, more sass from Hippler. Perhaps even more problematic and more telling is the utter failure of defense counsel now or any time to specify not only what needs to be reviewed, but more importantly, when that review would be complete and the defendant ready for trial. Ann Taylor has not said, Judge, I need 60 days. Judge, I need till the first of the year. Can we do this in January? She's not said that. I mean, and that's kind of shocking that she hasn't done that, because she could possibly have done that and said, Judge, Judge Hippler, Your Honor, I need 60 days. I need 90 days. Just please a little more time. And she didn't do that. And I do find that a little odd. Defendant seeks an unbounded continuance with no apparent plan to complete the review of unspecified evidence that counsel claims it has yet to review. This is not sufficient to warrant a continuance. This is what he says. We already talked about how she claims there's apparently red flags. Her mitigation team needs to run down for the mitigation phase. If it gets to that, the penalty phase. He doesn't believe there are any red flags. We went through that last night. He listed all of these things that they've already gone through. They've got his kindergarten through PhD educational and coursework records, his mental health and medical records, all of this stuff. Also, guys, on Monday, the witnesses who are supposed to be testifying or who've been subpoenaed by the defense, and I believe by the prosecution as well, have been summoned to court in Pennsylvania, and they have to show cause. One, Ann Parham, she is, I think, a former teacher of Bryan Kohberger. She's not contesting the subpoena any longer, but the others, as far as we know, are still being told, you have to be in court on Monday, all except for a woman named Maggie Sanders. Now let's get to the Dateline leak. He says the pretrial publicity issue is not a reason to delay the trial. A continuance is not warranted due to pretrial publicity. Defendant seeks a continuance due to recent inflammatory pretrial publicity on May 9th. 3 months before the trial, Dateline NBC aired a 2-hour episode about the case. The episode includes details and materials about the case, which are, if true, not publicly available and which promote a narrative of guilt. Defendant also advises that on July 9th, Amazon Prime is planning to release a docuseries. We've talked about that. And there's also a book coming out. The court does not agree that either argument compels a continuance. And this is why jury selection was originally set for 1 week. Now it's set for 2 weeks. And opening statements originally scheduled for August 11th will now begin on August 18th. So he's set aside an extra week for voir dire. So I think this is some sort of compromise on his part. Oh, this is what we're going to do. We are now going to do this instead, an extra week of voir dire. Defendant's right to a fair trial is not denied by the pretrial publicity, which is not likely to subside with time. So he's saying you can delay this all you want. It's not going to get any better. He goes back to the Sam Shepard case. That's the big case from way back when, an Ohio case where there was a huge amount of publicity. It's the landmark Supreme Court case where he got his conviction reversed in a new trial. What I find is interesting because he wanted an investigation into this leak, and so did she, right? And it looked like maybe she filed something for a fair investigation, and it was filed under seal. There's a footnote. In his reply, defendant argues that the allotted time is not sufficient for voir dire, given that the vast media coverage has taken place. The court recognizes that more time may be needed and has built in additional days for voir dire for this purpose. I just told you about that. There's no assurance that pretrial publicity will fade with time. The murders occurred over 2.5 years ago. The circumstances of the murders were provocative. 4 college students in a small Idaho college town were brutally stabbed to death by an unknown perpetrator. It was an immediate media sensation and garnered widespread attention that not only continues to persist, but continues to grow. He says it's not going to get any better. It's going to get worse. 18 months ago, defendant moved for a change of venue from Latah County due in part to the extensive inflammatory pretrial publicity and allegations made about Mr. Kohberger to the public by media that will be inadmissible at trial. He argued that Latah County was not large enough to avoid the bias caused by the pervasive prejudicial publicity. And so he got a change of venue. That was the remedy. The additional 10 weeks have not resulted in fading media attention. It has only given the media more time and opportunity to provide coverage to a public audience, which is clamoring for answers. He says the public wants to know. That's why there's more coverage. There's an appetite there. The longer the public is made to sit and wait for the facts to come out at trial, the more time there is for inflammatory speculative stories, movies, and books to circulate, and more time for prior ones to be rebroadcast, purchased, viewed, and consumed by the public. Proceeding with the trial as scheduled will likely avoid negative consequences for future publicity. Thus, the court finds a continuance is not warranted based on the media coverage. Then he gets to the leak part. This is where we get some really interesting information. It looks like somebody said, look at the Diddy trial. He had multiple documentaries before going to trial. In fact, defendant also asserts that a continuance is necessary to accommodate the special prosecutor's investigation. Oh, so there is an investigation. Defendant asserts that a continuance is necessary to accommodate the special prosecutor's investigation into the source of the leaks to the media and to impose accountability. So we do have a special prosecutor. With regard to the Dateline episode, defendant points out that Dateline represented that the material came from sources close to the investigation. He notes that Patterson's upcoming book on the crime promises claims to be the most comprehensive narrative of the book on the crime promises claims to be the most. Oh, sorry. I just repeated that sentence. I lost my place. The book on the crime promises claims to be the most comprehensive narrative of the investigation and evidence to date, and is based on over 300 interviews of several individuals, including the victims' families and local law enforcement. So let's go down to the footnote, number 23. Uh, in fact, long ago, sorry, we're missing 23. James Patter, he just references the book. I apologize. He says, as noted, a continuance is not warranted where the information sought thereby is mere speculation. Defendant's Brady argument, because they want to sit, they're saying if it's law enforcement, we need to be able to cross-examine that person on the stand about this. Defendant's Brady argument is built on a house of speculative assumptions, an assumption that there was a leak by persons bound by the non-dissemination order, an assumption the leaker or leakers will be found, an assumption that the leaker or leakers were law enforcement, an assumption that the leaker or leakers or others who maybe were complicit will be testifying as a government witness, and an assumption that these witnesses will likely be material. Such assumptions are not grounds for a continuance, particularly given that there is no guaranteed if and when they will be confirmed or debunked. So he said, basically, we could never find out. This trial cannot be held hostage indefinitely to the outcome of the investigation, particularly given the very significant chance the leakers may never be discovered. That's not what he made it sound like before. Thus, the court will not continue the trial pending the results of an investigation based on speculation that it will be successful and the hope that impeachment evidence may be uncovered as a result. So, denied. Let's go down to this footnote. I found this very interesting. Footnote number 27. In addition, even assuming it was law enforcement who leaked the information, the FBI played a preeminent role in the investigation of this case. If the leak or leaks were from the FBI, a state court's ability to further investigate is highly circumscribed and limited, if not altogether foreclosed. In addition, law enforcement in Pennsylvania and Washington may have had formal or informal access to some of the evidence, yet an Idaho state court may have significant limitations on the ability to investigate them. This is wild to me, guys, and I'll tell you why. This is incredibly wild to me because I thought if we have a special prosecutor and this is going on, everybody I've talked to about this, law enforcement, prosecutors, they think you can figure it out. They don't think this would be a hard thing to do. This is what I've been told. Digital footprints, phone records, all of these things. It could be one person. It could be more than one person. It could be a cop. It could not be a cop. It could be a member of the defense team. It could be a member of the prosecution team. He said, and he clarified this, he clarified his order from before. Let's look at this. There's a footnote, another interesting footnote here. While the court observed in its document and records hold order that it appeared likely that someone currently or formerly associated with law enforcement or the prosecution team violated this court's non-dissemination order, it could have been someone from the defense team or someone not subject to the non-dissemination order. The court has not made and was not, by this statement, making a finding or otherwise accusing law enforcement or the prosecution of such. So now he's kind of walking the back a little bit. I mean, he did say that. He thought they were the ones with the motive, but now he's kind of saying maybe not. So I found that really interesting. What do you guys think? Twizzlestick is in the house. He doesn't have jurisdiction to punish them, though, if they are from Pennsylvania, Washington, or the FBI. I think you're probably right about that. I think you are probably right. He doesn't have jurisdiction. Malibu says Hippler's point is that the case shall not be held hostage over this leak. Who benefits from the leak? BK. And a lot of people believe that. A lot of people believe it was somebody on the defense side that leaked this because it could help him. But I'm not seeing where it does help him. Felicia Herbstreith, I hope I'm pronouncing your name properly. Thanks so much for joining. Welcome. Appreciate it. Please hit the like, the thumbs up. I would appreciate that. Thank you. Apparently this Nightbot thing is in here. Tara Boop. I don't guys, we'll take care of this Nightbot thing for the future. I so apologize. We'll figure it out. Everybody's welcome in here. So if you're getting bopped by this Nightbot, I apologize. So let's take a look over here. This is I saved the best for last. So look at this, guys. We got to figure out what this is. June 27th, 2025. That's today. It's not posted yet, but it will be soon. We don't know what it is, but it says sheriff's return. Criminal. Is this going to end up being sealed? I hope not. When I see sheriff's return, that could be a return for a subpoena, a return for a search warrant. That's typically not on here. What is this a return for? I think of a search warrant return. What is it? And it says return criminal. Is this related to the leak investigation? Has there been some movement after Hippler wrote that? Do they know? Have they identified the source of the leak? Do they know? Has there been an investigation? I will let you know, all that I reached out. This is what I do. I reach out to people. Felicia says, thank you. So glad to be here. I'm not very techie, so I was afraid I'd never find how to become a member. Well, we'll try to make that easier in the future. I promise that. We're trying to get better at that. That's why I downloaded that Nightbot thing. And I think we're going to say bye-bye to the Nightbot. I already deleted them as a mod. So I got to figure out how to get them out of here permanently. So everybody, please be patient with us on that front. Amelia Outlaw says multiple jurisdictions, local, state, and federal, do not give someone a hall pass. I literally just looked it up. Good to know. Good to know. So, guys, maybe there's been some movement. Maybe they have. Maybe they've identified the leaker. But we're going to keep an eye on that for you on Monday. We're also going to keep an eye on that hearing that will be going on in Pennsylvania and Monroe County, where these people have to show up and say, I'm contesting the subpoena to Idaho. I'm not going. There's 6 or 7 people, maybe even more, including one of Bryan Kohberger's former professors from DeSales, Michelle Bolger. She was one of the people on the list. Her name was then taken off the list. I don't know. Maybe she's just not contesting the subpoena anymore. I don't know. Maybe they decided they're not going to subpoena her. There are also is now like this jail guard who's been added to the list, William Sirafos, and also this guy, Anthony Soma, who appears to have gone to school to the technical college with Bryan Kohberger at some point in time. So there you have it. But I do want to let you know, I reached out to the Moscow Police Department, to the chief, because that's what you do, right? You're trying to get information about a case. And I get it that I understand completely that there is a non-dissemination order. I get it. I understand. I get it. I mean, like, not to use that phrase, this is not my first rodeo. But we went to court, the media, back in 2023, because we found this non-dissemination order to be so restrictive and annoying and obnoxious. And I've worked around these types of orders, gag order type things in the past, where you can at least go to the parties on each side and say, look, you can clarify, you can ask questions about a motion, they can answer clarifying questions. These people haven't been willing to do that. And it's lame. It's silly. I get it. It's a big case. It's the biggest case of their careers. It's an important case. They don't want to screw it up. But guess what? It just, this whole shut it all down, not talking to anybody, is silly. So I'm wondering, I reached out to Chief Dollinger. I said, hey, is anybody in your PD on administrative leave? I sent him an email. I asked him straight up, is anybody on administrative leave in your police department? Investigators with Moscow PD would be some of the people with access to that information leak to Dateline, right? Members of the FBI, members of Idaho State Police. There would be detectives there. I don't think this is this huge circle. So he did not respond, just so you know. So I'm working on it. Twizzlestick says the NDO is more strict than you think. Well, I'm not sure it really is. And I'll tell you why, because I filled out a declaration in opposition to the gag order. We wanted it loosened up. It's really not that restrictive. I mean, they don't want them out on the courthouse steps screaming and ranting and raving about this. So yeah, beautiful messy ball. Exactly. The way to not screw it up is to make sure what you're reporting is correct and not a rumor. I couldn't agree more. I'll get you the link to become a member, guys. I'll drop it in the chat, but I think we're going to wrap this up. You know, we're going to wrap this up for the night. It's been a kind of a long week. I know I'm going to share now what I got in the mail from a wonderful friend of ours here in the chat. I think you guys are really going to like it. So I'm going to share that. And I think I'm going to make an emoji out of it. I'm working on the emojis. Let me drop this into the chat. And again, guys, we'll get rid of that Nightbot thing because I'm so sorry. We'll figure that out. Yeah, that's what it's what Tayo Toys sent. I just dropped the membership thing in the chat, everybody. So here's what Tayo Toys sent. It's so cool. I can't wait to show it to you. And everybody, I'm actually getting over being really sick. I was on vacation. I'm going to put a video together. You know that I did that one live from out in the wilderness. I don't want to tell you where I was yet because I want you all, I'm going to post like a standalone video of where I was so you can see how beautiful it was because it was really, truly amazing. And I'd like you to just like veg out and just enjoy the peace and solitude of it. But I got really sick at the end of the trip, super sick. It was really bad. And so I've been kind of moving like a sloth all week long. It's been rough. I'm thinking about doing a Sunday brunch, maybe a quick Sunday brunch, 30-minute live on Sunday. We can talk about other cases too. How does everybody feel about that? Let me know in the chat. So here's what and here's my booster pillow, guys. Like my booster pillow. It's like because I can't, my chair's not, it's not comfortable and I have to have a little pillow to kind of prop me up. So Taya Toys from my Law and Crime podcast sent this to me. So look at this. Look how amazing this is. I'm gonna hold it up so you guys can see. It's a crime fix car. I don't want to like. So look how cool that is. So it says Crime Fix on it, Crime Fix logo, right? And so then it's got Crime Fix on the side. And then my name. How cool is that? How cool is that? Oh, am I doing it wrong? There. Look what Tayo Toys sent. Sorry. So Tayo Toys, thank you so much. It's a beautiful Crime Fix car. Love it a lot. Rhonda Gaines, thank you so much for joining. Really, really appreciate it. I did an episode today, guys, of Crime Fix. Let me drop that in the chat for you so you can watch it. A little more put together without Nightbots interfering. And Josh Ritter, I wanted him to come on the chat tonight and talk with me maybe for 20 minutes about this, but he couldn't make it. But he did come on Crime Fix. So I'll drop that link in the chat too if you want to watch that. We talked about all of this. And Josh is super smart. He used to be a Los Angeles County prosecutor. Now he's a defense attorney. He hosts the Courtroom Confidential page on YouTube for the channel. And so he's great. So I just dropped the link to today's crime fix on this in the chat, so you can watch that and see Josh talk about it. So again, Rhonda, thank you so much for joining. So everybody, we're going to wind this down, wrapping it up for the night. Thank you again for joining and for becoming members. If you're watching on replay, thank you so much. Thanks for bearing with me and with the tech issues tonight. Remember to like, that thumbs up, hit the subscribe, the bell, all that good stuff. And I will see you back here next time. Thank you again for all of your support and for helping me bust through that 10,000 subscriber mark. That was a great surprise. Thank you for joining me and for supporting me. I really appreciate it. And I will talk to you soon. Also, let me know the cases that you want me to talk about, because I still haven't talked about Karen Reed on here, that verdict, or anything else. And I will see you soon. And have a great night. Bye.